day, ma'am. Good day, everyone. And presenting to you the topic Intellectual Property of Group 1.
What is intellectual property? This is creation of minds such as inventions, literary and artistic works, designs and symbols, names and images used to commerce. Category of property that includes intangible creations of the human intellect. Also, intellectual property is a term used to describe works of the mind such as art, books, films, formulas, inventions, music, and processes that are distinct and owned or created by a single person or group. Next is the intellectual property rights. Number 1, copyright. So what is copyright? This is related to the exclusive right to distribute. Number 2, copyright infringement. This is what we call yung paglabag. Ganon. So, ano naman ito? This is a violation of the rights secured by the owner of a copyright. Infringement occurs when someone copies a substantial and material part of another copyrighted work without permission. Number 3, copyright term. Right law guarantees developers the rights to their work for a certain amount of time. Number 4, eligible works. This is the types of work that can be copyrighted, include architecture, art, audiovisual works, choreography, drama, graphics, literature, motion pictures, music, pictures, sculptures, sound recordings, and other intellectual works. Number 5, the fair use doctrine. So what the meaning of this? Copyright law tries to strike a balance between protecting an author's rights and enabling public access to copyright works. The fair use doctrine allows portions of copyrighted materials to be used without permission under certain circumstances. And the last one is the software copyright protection. This is the use of copyrights to protect computer software raises many complicated use or issues of interpretation. The form of intellectual property. We have the copyright, patent, and trade secret. So what is the key terms of agreement? Copyright. This is computers program are protected as literary works. Authors of computer programs and producers of sound recordings have the right to prohibit the commercial rental of their works to the public. Next, the patent. Patent protection is available for any inventions, or whether a product or process in all fields of technology without discrimination, subject to the normal test of novelty, inventiveness, and industrial applicability. It is also required that patents be available and patent rights enjoyable without discrimination as the place of invention and whether products are imported or locally produced. Last, the trade secret. Trade secret and other types of undisclosed information that have commercial value must be protected against breach of confidence and other acts that are contrary to honest commercial practices. However, reasonable steps must have been taken to keep the information secret.
So, I will be discussing to you the three part of report in our presentation, which is Number one is the patent. Patent means is a grant of property right issued by the United States Patent and Trademark Office to an inventor. It means, ang patent na ito is pag magka-copy ng trademark ang isang company or someone, dapat may permission to the inventor kung sino yung gumawang originally. And then, the patent infringement is similar with the patent infringement. And next is the software patents, which is a software patent claims as its inventor some features or process embodied in instruction executed by a computer. So that means, ang patent is, for example, like the Microsoft, hindi pwedeng gamitin without the permission of the creator. And ang kabuuan ng intellectual property is it is a singleness property. Hindi pwedeng ma-share, hindi pwedeng ipakopya to someone. So, ang kailangan natin is permission. Kung kukopyahan man natin, kailangan ng permission yung totoong gumawa ng product. And one example is like sa FB page. Kapag magpo-post ka, which is hindi mo naman create yung page na yon to the other page na pagpo-postan mo, maggagamit ka ng hashtag permission to post admin, which is the PTPA, na kailangan hindi ka dapat nang hihimasok ng hindi mo page, which is kung magpo-post ka man doon, kailangan mo pa rin ng permission ng creator ng page na yon. So, yun lang yung 3 parts of intellectual property with regards to the patent. Thank you.
Sovereign patents and patent farming, a patented process or invention that is surreptitiously included with a standard without being made public until after the standard is broadly adopted is called a sovereign patent. The patent holder might demand royalties from all parties that use the standard. This strategy is known as patent farming. Patent troll, a firm that acquires patents with no intention of manufacturing anything, instead licensing the patents to others. Intellectual Ventures is an example of such firms. It has built a portfolio of more than 20,000 patents, most for IT-related technologies. Sovereign patents and patent farming. A standard is a definition that has been approved by a recognized standards organization or accepted as a de facto standard within a particular industry. Standards exist for communication protocols, programming language, operating system, data formats, and electrical interfaces. Standards are extremely useful because they enable hardware and software from different manufacturers to work together.
Sovereign patents and patent farming. A patented process or invention that is surreptitiously included within a standard without being made public until after the standard is broadly adopted is called the sovereign patent. The patent holder might demand royalties from all parties that use the standard, and that strategy is known as patent farming. Trade secrets. It is defined as business information that represents something of economic value, has required effort or cost to develop, has some degree of uniqueness or novelty, is generally unknown to the public, and is kept confidential. Trade secrets laws. Trade secret protection laws vary greatly from country to country. For example, the Philippines provides no legal protection for trade secrets. In some European countries, pharmaceuticals, medical diagnosis and treatment, and information technology.
Employees and trade secrets. Employees are the greatest threat to the loss of company trade secrets they might accidentally disclose, trade secrets, or steal them for monetary gain. Organizations must educate employees about the importance of maintaining the secrecy of corporate information. Trade secret information should be labeled clearly as confidential and should only be accessible to a limited number of people. Most organizations have strict policies regarding non-disclosure of corporate information. Key intellectual property issues. This section discusses several issues that apply to intellectual property and information technology, including plagiarism, reverse engineering, open source code, competitive intelligence, and cyber squatting.
Plagiarism, act of stealing someone's ideas or words and passing them off as one's own. The explosion of electronic content and the growth of the webs have made it easy to cut and paste paragraphs into term papers and other documents without proper citation or quotation marks. So, example ng plagiarism ay kunyari sa pagpapatayo ng ating business like halo-halo, hamburger, shake at iba pang uri ng merienda. May isang tao na gumaya sa iyong business. Ito ay tinatawag na plagiarism. Partial list of plagiarisms detection services and software. Nandito yung name of service, Authenticate, Turnitin, Safe Assign, GLAD Plagiarism Services, EVE Plagiarisms Detection. Nandito rin yung website na makikita natin sa Chrome at Google. Nandito rin yung provider. Ang Authenticate at Turnitin ay provide ng iParadigms. Safe Assign ay provide ng Blackboard. GLAD Plagiarism Services ay sila rin mismo yung nag-provide. At ang panghuli ay EVE Plagiarism Detection ay provide ng Canisius.
Okay, let me discuss about the reverse engineering. Reverse engineering is the process of taking something apart in order to understand it, build a copy of it, or improve it. Reverse engineering was originally applied to computer hardware but is now commonly applied to software as well. Reverse engineering of software involves analyzing it to create a new representation of the system in a different form or at a higher level of abstraction. Often, reverse engineering begins by extracting design stage details from program code. Design stage details about an information system are more conceptual and less defined than the program code of the same system. Okay. In a simple words, reverse engineering is the act of dismantling an object to see how it works. It is done primarily to analyze and gain knowledge about the way something works, but often is used to duplicate or enhance the object.
Open source code. Open source code refers to any program whose source code is made available for use or modification as users or other developers see fit. Open source software programmers can actually charge money for the software that they create or help out with. What is open source codes? Open source software is code that is designed to be publicly accessible so anyone can see, modify, and distribute the code as they see fit. Open source software is developed in a decentralized and collaborative way, relying on peer review and community production. Open source software: 7-Zip, Aris Galaxy, Audacity, Azurius, Blender RD, Emule, Eraser, Firefox, OpenOffice, Video Dub. Purpose: file compression, peer-to-peer file sharing, sound editing in special effect, peer-to-peer file sharing, RD modeling and animation, peer-to-peer file sharing, erase data completely, internet browser, word processing, spreadsheets, presentations, graphics, and database video editing.
Competitive intelligence is the process and forward-looking practices used in producing knowledge about the competitive environment to improve organizational performance. It involves the systematic collection and analysis of information from multiple sources and a coordinated CI program. The importance of competitive intelligence is because it helps business understand their competitive environment and the opportunities and challenges it presents. Businesses analyze the information to create effective and efficient business practices.
Cyber squatting. Cyber squatter register domain names for famous trademarks or company names to which they had no connection, with the hope that trademark's owner will eventually buy the domain names for a large sum of money. A trademark is a logo package design, phrase, sound, or word that enables the consumer to differentiate one of company's products from another's. Examples: cyber squatters may also utilize varying top-level domains in order to compel trademarks owner to buy the website. Cyber squatting is a registering, selling, or using a domain name with the intent of profiting from the goodwill of someone else's trademark. It generally refers to practice of buying up domain names that use the names of exciting businesses with the intent to sell the names for a profit to those businesses.
That is the end of our report, and our topic is all about intellectual property, which is we discuss here the all types of intellectual property. We hope that you like it and appreciate it, ma'am. Again, thank you so much for giving us this kind of report. Thank you again and have a great day.